full recovery. So, Mr. Mead, I'm going to wish you the best of luck. And again, the most important thing to me is not the money. That's part of the deal. But the most important thing, again, I can't emphasize that enough, is you just drive safely, drive unimpaired. That's the best thing. Any questions at all? Pardon? No, it's you can get a copy of the order. You don't need to acknowledge receipt of it. I'll just want you to have it to remind yourself of the court date. I'm going to wish you the best of luck, and you don't need to come back again unless there's a problem, and we'll swim that river when we get to it. And hopefully that was, never know what the future is going to bring. We just hope for the best. I'm going to wish you the best of luck. You take care of yourself. And yeah, stay well, stay healthy. Okay. That's all. Yep. Just follow the doctor's orders. Hey, bring him up. Good morning, Mr. Coombs. You're muted. Hey, thank you. Can you hear me?
I can, Your Honor.
You're here on behalf of Mr. Boyle, I believe.
Correct, Your Honor.
Mr. Boyle in the courtroom.
He is not. I told him he didn't have to attend. We submitted his missing information school last night at approximately 5:02 p.m.
Today.
Yeah.
It's just received this morning. That was one of the first things I checked on when I got here 45 minutes ago, and hadn't arrived yet, but it now has arrived. Yes, I'm looking at proof of ADAS compliance. Will strike the hearing.
All right. Thank you, Your Honor.
Give our best to Mr. Boyle, and I hope all's going well with him in his life.
Yeah. Thank you so much.
And thank you for the information.
Okay. All right. Thank you.
Scott DePasquale is not here. How about Selena Menish? Good morning. How's life? That was, it looks like it's a compliance issue with both things, I believe, substance and mental health. What's going on? May have heard me say this a few moments ago. Most important thing to me is you haven't reoffended. You have no new charges appear on your record. You are out of compliance with some order treatment, but I think it sounds like you have a pretty good reason for not being in compliance. It sounds like a financial issue more than anything else. How is life going otherwise? It sounds like you're dealing with it though. And that's all I can expect you to do. I can't expect you to do any more than that. The city have any input or any suggestions?
Well, city tax leader.
This does have some age on it. Yeah, what I'm inclined to do is reset the matter. May 22nd. Is that acceptable to the city? We're going to reset the matter to 22nd of May, and we'll just take a look and see how things are then. I want you to, the worst thing you could do here is give up on yourself. I don't want you to do that, okay? This treatment, substance use and mental health, that's to help you through this. That's what it's for. If you can't afford it, you can't afford it. But I want you do have a prospect of employment here, it sounds like. Follow through on that, and let's just take another look at it on May 22nd. But the most important thing I think right now is just keep up the good fight. Don't give up on yourself, and just stay well. Be well as you can, and deal with situations as they come up. Any questions at all? Menish, I'm going to sign the order, resetting the matter. It has the date and time on the order, and I'm just going to wish the best for you in the meantime, and we'll take a look at the matter and when we get to May and just see where we are at that time. Any questions at all? I want to thank you for appearing, and don't forget to get a copy of the order at the window before you leave. Take care. Be well. And with that, DePasquale is not here. That case goes back to 2009. City wish a warrant on 1,000 cash or bond. So ordered. Go on. On record for the 8:30 in custody. Mr. Haverco, I can see you. Are you able to hear me okay?
Yeah, I can hear you pretty well, yeah. Thank you, Your Honor. But the matter comes before the court, this individual's name is Alexandria Mary Johnson, and she comes before the court this morning for an arraignment. We would like to proceed with a formal arraignment and then would like to address release conditions.
Good morning, ma'am. Is your full name Alexandria Mary Johnson?
Yes, Your Honor.
Ms. Johnson, the citation I have alleges that on or about March 25th, 2025 here in Yelm, you committed the offenses of driving under the influence of intoxicants and operating a motor vehicle without ignition interlock when required to have that by the Department of Licensing. Each of those is a gross misdemeanor. Maximum penalty for each would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverco to enter a plea on your behalf. He'll represent you throughout the course of the matter, should you be indigent.
And Your Honor, I'd have an opportunity to review the probable cause statement, which stipulates probable cause, and ask the court to enter not guilty pleas to both charges.
Plea of not guilty is entered. We're going to set the matter for a pretrial here in a moment. In the meantime, would you like to address conditions of release?
I would. I would note that I think Your Honor, my understanding is probably ordered her to have an ignition interlock device and all that. This vehicle apparently she was driving was belonged to a friend. Apparently, she has an interlock device on her car that she normally drives. She does have a place where she stays in West Olympia, I believe the court, which has the address to that. She has a friend that potentially can help her on the outside. But what we're looking at here is she understands the gravity of the trouble that she's in. She's very sorry for what happened. We'll need at some point to conduct a chemical dependency evaluation, and it's highly likely that she's going to be petitioning at some point for deferred prosecution. My experience is that while not impossible, it can be really, even if you have the money, it can be really difficult to get some of the treatment providers to travel out to the jail and do an evaluation. I know that's happened, but I had some difficulty trying to make that happen recently with a different client. And so if there's some set of conditions the court could fashion to consider otherwise releasing her on her own recognizance with a return date, so that she is in a better position to, obtain a chemical dependency evaluation, that would really be helpful, because that's really the direction we probably are going to need to go.
Thank you. Mr. Radfield, Ms. Johnson, I'm inclined to release you on your own recognizance on the conditions I outlined when we spoke on the telephone shortly after you were arrested. No criminal law violations. Don't drive unless licensed and insured. I don't want you consuming any alcohol or non-prescribed drugs. Don't drive after you've been drinking at all. Don't drive without any vehicle without ignition interlock in it. I want you to file proof. You indicated that you did have ignition interlock in your own vehicle. I want you to file proof of that within 5 days of today. And again, no drinking, especially no drinking and driving. Any question about what I've just said?
No, I understand completely, Your Honor. I am very, very apologetic for everything. It really was just a stupid mistake.
We're going to set the matter for a pretrial on April 10th. That's a couple of weeks from today. We'll be sending down a release order to the jail. It'll have the court date and time on that order. Look forward to seeing you on April 10th. Okay.
And if Your Honor would just Give me just one moment. I just want to ask my client one question before we leave this matter.
Certainly.
Okay, everything's fine, and thank you, Your Honor, for your ruling, and see you on the 10th.
Mr. Havergo, you take care. Have a good day.
Thank you.
Ms. Johnson, good luck. We'll see you on the 10th. Again, I'll be emailing down, my staff will, an order of release here very shortly. You take
Thank you, Your Honor.
That's really good.
Oh, there is already. All right. All right. Yes. Mr. Coombs again. Five and six, yeah, or 4 and 5. Oh boy. Go ahead and bring that. Mr. Coombs, good morning. If you'd unmute yourself, we'll address, and it looks like you have perhaps a number of matters on the calendar. I'll defer to you for the order in which they're called.
Yes, Your Honor. Lily Bonner, Eric Mwaniki, and Jackson Stanley. Mr. Mwaniki and Stanley are setovers. If they are in the court presently, we can take care of those. I don't see Lily in the court right now.
There's people coming in. Lily Bonner is not here, but yes. I think Mr. Mwaniki is here. Sir, come on up and have a seat if you would. I see in Oakhart's a motion to reset the matter to May 22nd.
Yes, Your Honor.
And that will be at 9 a.m. in the morning. City, have any objection to the matter being reset? Signing the order, resetting the matter to May 22nd at 9 a.m. Mr. Mwaniki, you can get a copy of today's order at the window outside the courtroom to your left, and we'll be sending your attorney a copy as well.
Thank you.
Any questions at all?
Not today, Your Honor.
Any conditions released earlier set remain in effect?
No.
Thank you, Your Honor.
Signing the order electronically as we speak. That is done. That concludes the hearing. Don't forget to get a copy of the order on your way out. Mr. Mwaniki, take care.
Thank you, Your Honor.
See you in May. And Lily Bonner does not appear to be in here.
Jackson Stanley.
Jackson Stanley in the courtroom. Mr. Stanley, have a seat.
And this is also a set over, I believe, to the same date, Your Honor.
For the record, your name is Jackson Scott Stanley. That's it. City, have any objection? Request of your attorney, we're setting the matter over to May 22nd, 2025 at 9 a.m. We're preparing that order as we speak. Again, conditions of release or law-abiding behavior, that would include any moving traffic violations of any kind whatsoever. When the order is prepared, I will sign it and you can get a copy of that on your way out at the window. We'll also be sending a copy to your attorney. Any questions at all? For some reason doesn't want to go to 9 o'clock. Can I make? I could try. O Courts is giving us a little bit of difficulty, Mr. Coombs.
I understand.
Kind of a problem elsewhere as well. Order is now prepared. Soon as there it is. Order is now signed. Mr. Stanley, I want you to get a copy of that at the window outside the courtroom to your left, and we'll see you here next time. Again, your attorney can't appear by way of Zoom, but I need you here in person. Any questions at all? Take care. Have a good day. Don't forget to get a copy.
Thank you, Your Honor.
Once again, Lily Bonner. Ms.
Oh,
Bonner,
she's,
come on up and have
there
a
she
seat.
is.
He's present by way of Zoom. Good morning. Ms. Bonner is now at the council table.
Hi, Ms. Bonner. And Your Honor, this is a motion to close this matter early. She entered into an agreement to where this was going to get closed, I believe, at a further date, but we're asking to close this early because she has diligently and promptly done all that is required of her. She paid her court fine in full. She did her information school. She did her victim impacts panel. And then there's another component to this, which is the fact that she has a son who's incarcerated, and she has not been able to visit him over the past year because this case is still open. She has not been able to visit him during the holidays. He just completed his GED. He's got a graduation coming up that she would love to be able to celebrate with him at the facility. And she cannot do that until this is resolved. So we are asking the court to close it at this time.
This is an SOCA plant, I think. Guilty. There's a guilty plea November 24. So do you have any position in the matter?
Well, city would like to exert its jurisdiction for the remainder of the term. I believe the consequences of the guilty plea were known at the time of its entry.
I'm sorry, Your Honor, I did not catch what the city said.
Okay, yeah, we have microphones here. Go ahead, Mr. Atfield.
The consequences of the guilty plea were known or should have been known at the time of its entry. The city would like to exert its jurisdiction for the remainder of the term. The consequences are unfortunate, but they are necessary.
Your Honor, if I may.
Certainly, go ahead.
I respect that. I would say that again, given the fact that she diligently complied with all of the requirements. She is shown to be responsible. She has been in continuous contact with our office. And, the fact that her son is incarcerated at a facility and she cannot see him, she could not even see him over the holidays, I believe is, I mean, not necessarily a foreseeable punishment, and it's a punishment that has certainly made her aware of the consequences of her actions. And at this point, I think it would be fair for the court to consider closing this early so she can see her son.
How old is her son?
29. I was in the middle of doing the visitation process when I had this horrible incident, so it got denied. And even though it's not extremely criminal, they just won't let you have visitation at all. His father had passed in an accident, and then he just kind of went spiraling out of control.
Ms. Mother, I'm very sympathetic to your situation. As your son made his choices and he is there where he is, I don't know why, but I presume because of his choices. And that's what we have here. I'm going to deny the motion, and for the reason of the in 2015, the situation you had to there were the prior offense. I think given that, I'm going to preserve the city's jurisdiction. I'm not going to extend it a year, but I will leave it at it.
Is there anything that can be done so they allow visitation? I mean, it just seems silly to me that I can't.
That's
even because
going to
of
be
this.
something you're going to need to discuss that with your attorney. That's something there. That is, it's a hard call for me to make, and again, I have a great deal of sympathy for the situation your son is in and the situation that you're in. As a mother, there is no love like the love of a mother. I realize that. I'm going to wish you and your son the best.
So what does that mean then? Does that mean that's closed in a year? What does that mean for me as far as this case?
What that means to me, you're still under the jurisdiction of the court, this court, with regard to the Neg 1 charge until November of next year. Again,
Okay,
this
so
is a matter you need to discuss with
okay.
with your attorney. Hey, thank you, ma'am.
Thank you.
Concludes the hearing. You're excused.
Thank you, Your Honor.
On presentation, I'll sign the order. Mr. Duenhalter is on. Let's bring him up here. Mr. Mold, I believe you're here on behalf of the parents, maybe? Armando Acevedo Hernandez? Mr. Duenhalter, good morning. Your client is in the courtroom. Good morning to you.
Good morning, Your Honor. May it please the court, Martin Duenhalter on behalf of Mr. Acevedo Hernandez. Thank you for calling my case, Your Honor. I will have to say, I sent last time we continued it for me to get discovery. I then sent, the emails must have gone nowhere, but we then sent it United States mail. Well, due to my own error, I wrote 1800 and the letter went to 800 Cooper Road Southwest, but it came back as undeliverable. The one was not legible when I gave her the address. So this is entirely on me. With the court's indulgence, I would ask for a continuance. I still don't have discovery. I don't know. Mr. Ratfield, could you confirm that you guys got that letter? We sent it on the 19th. We sent it first on March 7th, but that came back. And we sent it again on March 19th.
I haven't
You,
received it yet.
you do or do not?
I do not have it yet.
I suppose even the Pony Express would have gotten it there by then, but you don't know nowadays with the United States Postal Service. How do you Well, Your Honor, that's essentially it. I still haven't had the discovery or ability to talk to counsel about the case.
We do have the cart before the horse here for a little bit. Mr. Mold is here.
Oh, I'm so sorry.
We swear or affirm that you will, and you have translated from Spanish to English and English to Spanish, all that has been said here.
Yes, I do.
Thank you. Good morning, sir. Full name, Armando Acevedo Hernandez. Mr. Duenalter, I guess this is a motion to reset the matter to a future court date. How far out would you like to go?
Oh, let's see. The Yelm Court meets on Thursdays, is that correct?
That's right. April would be 10th and 24th.
17th is open and 24th, I have a King County, but that should be quick. That'd be fine.
City have any objection to a reset?
No.
At the request of the defendant, we're going to reset the matter to the 24th, and hopefully council's in contact and we'll be able to exchange the necessary discovery and information.
Counsel, is there a possible way that you, I have your email, but I don't know that we've had any luck. Would you like me to try to communicate with you via email?
Or telephone would be good too.
Oh, wonderful. I'm all behind that. I will do that.
Great.
I just didn't know if you were still part of the old school generation that actually could speak with one another, and it's refreshing. Thank you.
Picking up the phone.
Going to reset the matter to April 24th. We'll need, I guess,
Yeah, and for the defendant's edification, and the translator could translate this, we'll have to sign a speedy trial waiver, which begins the clock again at that time. And I think we've done it in the past and discussed it, if that's okay with Mr. Acevedo Hernandez.
I will note for the record that the continuance is at the request of the defendant, which.
Yes,
takes
thank
care.
you.
Excuse me, Your Honor, the interpreter didn't get the part about when it was actually going to start the calendar.
April 24th.
Oh, the April.
That-
24th, but
that
the
will
speedy
reset.
Trial waiver,
Yes,
and when would that begin? On the 24th?
yes. It restarts on the 24th of April by rule. I guess we're gonna need the, in O courts, the motion to continue.
I can prepare that.
And Mr. Ratfield is preparing that as we speak. That'll take a moment to go. Mr. Acevedo, any conditions of release earlier set remain in effect. And that includes, of course, stay in touch with your attorney and be back here on April 24th. Any questions? Hold on. Don't have an order. I am now. Looking at an order. I'll be signing it here electronically in a moment. When I do, I want you to get a copy of that at the window, and Mr. Mold will help you with that. It now loaded.
It might be up.
It is here. Just got it. Mr. Acevedo, that now concludes the hearing. I've now signed the order. You can get a copy of that at the window, and we'll be sending your attorney a copy of today's order as well. Mr. Duenal,
Thank you, Your Honor. Appreciate the court's time. May I be excused?
You may be excused. We'll see you again on the 24th at 9. We'll send you the order.
Thank you. And Mr. Ratfield, I'll try to be in touch. Thank you very much.
We do the best we can. It's Mr. White.
I'll be presenting for Mr. White and
Okay.
be a continuing.
And we do
What's
have
your name?
Shannon Foley, I think.
What's last name?
Let's do that.
Good morning, Your Honor.
Ms. Foley, we'll take your matter at this time, here on behalf of Fernando Reyes.
That's
Mr. Reyes,
correct, Your,
if you would. Good morning. Good morning, Ms. Foley. I see in O Courts, a motion to reset the matter.
that's correct, Your Honor. We are requesting May 22nd at 9 a.m. for another pretrial for ongoing negotiations.
City, any objection? I see a speedy trial waiver
No objection.
with a new commencement date of the 22nd. Hearing no objection from the city, I'm going to sign the order. I'll make sure your client gets a copy of that before he leaves, and we'll be sending yourself a copy of today's order as well. Any questions at all?
Thank you, Your Honor. I just had one. I believe it's this court's practice that defendants need to appear for every hearing. Mr. Reyes is having some difficulty finding transportation due to this case. He's not able to drive while on the base, which is where he lives, meaning he can't keep his vehicle with him and have it accessible. So I would be asking to waive Mr. Reyes's appearance at future hearings unless, of course, we're entering a disposition or having a substantive motion hearing or something of that nature.
I have no objection from the city, as long as I would want him here for a dispo or a motion, any kind. But other than that, certainly if it's simply a reset or something that can be done without him needing to be present, I have no objection to him appearing by way of Zoom.
Thank you, Your Honor.
Mr. Reyes, any conditions released earlier set remain in effect. I want you to get a copy of today's order at the window before you leave. Be in touch with your attorney, and yes, unless your attorney tells you otherwise, you don't need to be here in person for the next scheduled date on May 22nd. Any questions at all?
No, Your Honor.
Go ahead and get a copy of today's order, and we'll see you here end of May.
Thank you, Your Honor.
Ms. Polly, thank you. We'll be sending you a copy of today's order as well. You take care.
Thank you. Thank you, Your Honor. I actually had one other matter that I'm covering for Mr. Murphy, Christopher Robinson.
Chris Robinson in the courtroom?
I believe he is actually in custody in Thurston County, Your Honor.
That sort of changes things a little bit.
It does.
Any idea how long he's going to be in custody, or is that to be determined?
To be determined, but speaking to his attorney, it does sound likely that he'll be there for a while. He's being held on some pretty serious charges. Mr. Murphy did upload a continuance form with a waiver asking for that same May 22nd date and hoping to have kind of some more information by then.
If you're in touch with Mr. Robinson, we'll note that on the trial purposes and reset the matter. You're here on May 22nd anyway. May as well go to that.
Thank you, Your Honor. And Mr. Murphy, his attorney of record, is in touch with him, yes.
Okay, great. And we'll hope that things work out. Well, at least no more information then, I hope, maybe.
Certainly, hopefully.
Signing the order electronically. We'll be sending you a copy of that as well. And you take care. Have a good day.
Thank you, Your Honor. You too.
Need to be patient. with Oak Courts this morning? Well, Tania Gamboa Placencia. They're outside. Didn't see him. Mr. Cole. Apparently, not for city wanted to present on Rosalie Cole, docket number 3 on behalf of Mr. White. I see a motion. I'm bringing up a motion in Oak Courts to reset the matter to May 8th at 9 o'clock.
Yes, I've been in contact with
Signing the order, resetting the matter. Even he is in touch with his client. We'll send Mr. White a copy of the order, as well as Ms. Cole. Next, we'll call the matter of Yelm versus Tania Gamboa Placencia. I probably mispronounced that again, and for that I apologize. Matter set for pre-trial. I'm going to refer to your attorney for the status of the matter.
Good morning, Your Honor. Attorney Crone here.
Thank you, Mr. Cohen. And do you disagree with anything at all that Mr. Cohen just said?
No.
City have anything to add? this is a contract, stipulated order of continuance. It's an agreement. Your attorney's negotiated on your behalf with the city. Your attorney's put you in a very good position here. You're in a position of being able to get this charge wiped out, dismissed. A year from now, if you comply with the conditions, and they're pretty simple, stay out of trouble. I guess no fine is being required, or there is a requested fine. It says 0 at the current time, but subject to amendment. Oh,
I tried to.
there it is. There it is. Old courts is a little bit of a.
Yeah.
That was, the money is the least important thing to me, but it's there. The most important thing to me is you learn from this. When you're in an accident, it's required that you exchange operation information with whoever's involved in it. If you don't hit attended is a gross misdemeanor. Maximum penalty on conviction is 1 day short of a year in jail and a very large, possibly a very large fine, $5,000. And perhaps even more importantly, it really doesn't do any favors at all for your driving record and your insurance rates. Now, in return for this agreement, you've given up the rights contained in the agreement. No trial, no appeal. If the city proves by a preponderance of the evidence that you violated the agreement, we'll have a hearing based on the police reports, and that would subject you to the possible maximum penalties. We don't want to go there. The attorneys put you in a position that it's up to you to comply from here on. You've got a lot of driving ahead of you, and the lower your insurance premiums and the safer you are, the better off your pocketbook and you will be. I'm going to wish you the best of luck. You take care of yourself, and again, I'm hoping that we'll simply be able to close the matter with a dismissal 1 year from now. Any questions at all?
No.
Thank you,
Thank
ma'am.
you.
Take
Thank
care.
you.
Mr. Crone, good to see you. Take care. There'll be copies at the window. You take care. Hopefully, Old Court's better than the last time, but see you then. Be right, you two. Take care. Be well. Sir, are you here waiting for your attorney? 9:45? Your name is? Yep. Jazzy, the public defender is not here yet. He's on his way here from the jail. Once he gets here, we'll call your man. Sure, if you, we do have. Oh, okay, right. Yeah. Rivera?
Yeah.
Get his license. And he is relicensed, huh? Oh, wow. He paid his reinstatement fee immediately.
No, I haven't talked about it here.
Just to reinstate.
Do we want to reset?
Oh, yeah. I am trying to open On record, Mr. Haverko, I'll defer to you for the order.
Okay, Your Honor, why don't we, there's one matter that's ready on the 9:45 calendar. and
Mr.
that would be-
Yazzie,
Mr. Yazzie.
come on up, have a seat, sir. Good afternoon, sir. Is your full name Jared A. Yazzie? Mr. Yazzie, you went into warrant status. You're here for an arraignment on a malicious mischief third charge that goes back to June 12th of 2018. It's got a little age on it. Malicious mischief is a simple misdemeanor. The maximum penalty on conviction would be 90 days in jail and or $1,000 fine. I'm going to appoint Mr. Haverko to enter a plea on your behalf. He's going to represent you in this matter.
Stipulate probable cause, Your Honor, ask the clerk to enter a not guilty plea.
We have not guilty, preserves your rights pending the pretrial. And gee, what a shock. Christina Russell in the courtroom? No. So as you were setting a pretrial for May 8th. Now, you have given your contact information to Mr. Haverko? Pardon?
Another day somewhere. Could we bump it out 2 weeks?
Well, I went and signed the thing.
Oh, oops. What time is your
Did I
flight?
somehow unsign it? No, wait, okay.
Are we doing a new one?
Trashed, okay.
Okay.
So as you have to prepare a new order here. 2018, that's a while back. Glad to see we're finally, glad to finally see it.
Oh,
boy.
I've advised him to, prior to his next hearing, to contact the clerk and find out if the court would give him permission to appear.
May 22nd.
Okay. You don't need to write that down. But you're gonna get a copy.
Conditions of release, law-abiding behaviors. Stay in touch with Mr. Haverko and be back there on the 22nd. Or check and see if you can't appear by Zoom. That'd be okay. Any question at all? What I want you to do is go to the window outside the courtroom to your left, get a copy of today's order, and we'll see you or talk to you on the 22nd. Any questions?
It's working. Okay, I'll sign.
And Christina Russell has not appeared. She's also on the 1 o'clock calendar, new offense.
Oh, yeah, and I don't, is there a Allison Bartlett or David Jackman or Eladi Mbengi or Joshua Roos here? Those are all the folks on the 9:45, so. I guess that was our only,
not batting, not batting 1,000.
yeah. Let me get to the 10 o'clock here. Well, Mr. Ruelos is here on the 9:45.
Ah.
Yeah.
Mr. Ruelos is here representing himself, set for a pretrial. How far out? May 22nd?
Yeah.
Just a notice. Morelos, we're going to reset to May 22nd. And you need to be back here at that time. You can, what I want you to do is go to the window outside the courtroom to your left, get a copy of the notice. It'll remind you of what time and what date you're supposed to be here. Thank you for appearing and good luck to you. Take care.
Mr. Pace?
And this is?
This is, Michael Pace, last name Pace.
Good afternoon, sir.
So the matter comes on for a pretrial hearing and parties have reached an agreement, that being a stipulated order of continuance. And what's to happen is the case is to be amended to hit and run unattended today. And then that charge placed in the stipulated order of continuance for 12 months on two conditions: no new criminal law violations and the payment of a $250 probation fee, at the end of which time that matter would be dismissed.
Good morning, sir. Is your full name Michael Antonio Pace? Mr. Averco has negotiated an agreement under the terms of which a reduced charge at this time can be fully dismissed a year from now if you have no criminal law violations and pay costs in the amount of $250. You've given up your rights to go to trial, no trial, no appeal. In return for this, if the city proves you violated this agreement, we'll have a hearing based on the record, and that would result in more likely than not a conviction for a misdemeanor, which would bear up to 90 days in jail and up to $1,000. I'm going to wish you the best of luck. I'm signing off on the SOC, the agreement, as we speak. What I want you to do is go to the window outside the courtroom to your left, get a copy of the agreement, read it over carefully later today. And if you have any questions at all about what it means or what your obligations are, give Mr. Averco a call, okay? Any questions of me? I'm going to wish you the best of luck. We all make mistakes. The point is we better learn from them, hopefully. Good luck to you.
Next matter is going to be Royce Bedeau.
Good morning, sir. Full name Royce Bedeau.
Yes.
Good. Royce Anthony.
Matter comes on for the court for driving under the influence charge. Parties have reached an agreement, that being a stipulated order of continuance, 2 years. The same conditions that would otherwise be imposed on a DUI, so that obtain an alcohol evaluation, comply with any recommended treatment, DUI victim impact panel, $990.50 fine that would have been imposed on the DUI. And again, the evaluation and comply with any treatment recommendations. So either alcohol drug information school or treatments recommended, to comply with that. At the end of the agreement period, then the charge would be amended to negligent driving in the first degree.
Mr. Bedeau, do you disagree with anything at all Mr. Haverco just said? Not at all. I'll start by saying that a DUI conviction is terrible. It's worse in terms of impact on your life, your driving record, et cetera, than a lot of felony convictions would be. This is a 2-year agreement. Over the 2 years, stay out of trouble, get the alcohol and drug and evaluation, and comply with any recommended treatment. At the end of 2 years, the charge will be reduced to a much less serious charge of negligent driving first degree. Now, if you violate the agreement, the city proves that by a preponderance of the evidence, we'll have a hearing, based on the police reports, and that would, very likely not go at all well for you. I'm approving of the agreement. I want you to get a copy of it at the window, read it over carefully, and if you, have any questions about what it means, give Mr. Haverko a call. DUI, it's as tough of a, conviction as there is because of just simply because of the number of people we kill out there in the roads, every year. Any questions at all, Mr. Widow? I'm going to wish you the best of luck. You've been placed in a very favorable position here, but it's certainly up to you to take advantage of that, okay? Good luck to you. Thank you.
Here you go. Yeah, just go see the, yeah. Kyle Blazel or Blazel.
Morning, sir. Is your full name Kyle Joseph Blosel?
Yes.
Mr. Haverko?
1 second here. So the matter comes before the court for a pretrial hearing on a criminal trespass first degree theft, a theft charge as well. Parties have reached an agreement. He's going to enter a straight plea to count 1, criminal trespass first degree. Upon the court's acceptance of the plea, city will move to dismiss count 2, the theft charge. Conditions for the next 12, all suspended jail time for the next 12 months. Conditions are no new criminal law violations, $250 court fee.
Mr. Blosel, do you disagree with anything at all Mr. Haverko just said? I am, as he indicated, I'm looking at a statement of defendant on plea of guilty to 1 count of criminal trespass first degree, referencing a dismissal of the accompanying theft third charge. Crim trespass 1 is still a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'd be free to impose that regardless of what's recommended if I saw fit to do so. Accept the plea, you give up the rights contained in paragraph 5. There's no trial, no appeal, simply a sentencing. With that in mind, is to 1 count of criminal trespass in the first degree alleged to have occurred within the city of Yelm on December 7th, 2024. How do you plead, guilty or not guilty? Do you make that plea of your own free will? Anybody make any, do you make that plea of your own free will? Anybody make any threats or promises to you to make you plead guilty? I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the plea. Mr. Haverko has indicated what the recommendation is going to be. Anything you'd like to tell me? Mr. Ratfield, anything you'd like to add? I'm going to follow the recommendation. All jail time, 364 suspended on the condition you pay a $250 fine by way of a probation fee, and also that, most importantly, stay out of trouble. We all make mistakes. We have to learn from them or we're bound to repeat them. That applies to each and every person in this room, including me. I'm going to wish you the best of luck. Mr. Blazel, what I want you to do is get a copy of the paperwork we've generated here at the window. Look it over carefully. And if you have any question at all, give Mr. Haverko a call. I'm going to wish you good luck. You take care of yourself. Thank you.
Ms. Crary.
Good morning, ma'am. Is your full name Kristen A. Crary?
So matter comes on for the court this morning for a theft charge, pretrial hearing. And we placed into O courts a motion for continuance along with a speedy trial waiver. When did you put that? For the. She's got some Superior Court matters, the trial date of which is in May. So we put in a long waiver, so we'd like to set a date after that trial date.
Trial in May.
Yeah,
I'm gonna suggest June,
yep, that's perfect.
June 5th or 16th. 16th is that Monday date, which it's on Monday. Would that work?
Either way.
Ms. Curry, at the request of your attorney and yourself, we're gonna reset the matter out to a later court date to give you a chance to work on other issues you have. Conditions of release are just stay in touch with Mr. Haverco, law-abiding behavior, and appear back here for court on June 16th. Signing an order to that effect. What I want you to do is get a copy of today's order at the window and be back here in June. Any questions at all? Good luck to you on this and your other matters.
Mr. Phobes? It's okay.
Hey,
I see. Oak Courts is being a little slow.
we're all experiencing the same thing here.
Yeah.
So, in any event, it's your full name, Marcus Allen, folks.
Give me 1 second. So the matter comes before the court, pretrial hearing on the theft charge and criminal trespass first degree. I anticipate he's going to enter a straight plea of guilty to count 2, criminal trespass first degree. Upon the court's acceptance of the plea, the city would move to dismiss count 1 and all suspended jail time, suspended for 12 months on the condition of no new criminal law violations and a $250 forfeit.
Mr. Phobes, you disagree at all with anything Mr. Haverco just said? I'm looking at this screen at a statement of defendant on plea of guilty to 1 count of criminal trespass first degree. Referenced is a dismissal, if I accept the plea, of the theft charge, third charge, which accompanies this. Have you gone over the plea process with Mr. Haverco? And you feel you understand what it's involved in entering a plea of guilty to a criminal matter? The charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine, which I'd be free to impose regardless of what's recommended. You realize that. Also, the rights contained in paragraph 5 would be gone. No trial, no appeal, simply a sentencing. With that in mind, Mr. Phobes, as to 1 count of criminal trespass in the first degree alleged to have occurred within the city of Yelm on February 8th of 2025, how do you plead guilty or not guilty? You make that plea of your own free will. Anybody makes any threats or promises to you to make you plead guilty? I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. Mr. Haverco has indicated the recommended sentence. Mr. Ratfield, anything to add? Folks, you have a right to tell me anything you wish. You don't have to say anything, but if you want me to know anything about your situation here, don't see any reason why I shouldn't follow the recommendation, and I will. 364, all suspended on the condition. You pay $250 probation fee, but more importantly, stay out of trouble. Law-abiding behavior. Sure. Yes, and I will. We're getting to that. Yes, you did. I know from the docket you did. I posted bail, and with the disposition of it, bail's exonerated. I don't know whether that was a cash bail or a bond posted. If it's a bond, bonding company will be notified. If it's cash bail, posted by yourself or somebody else, it'll be returned to whoever posted it. That answer the question? That's it. Mr. Forbes, I'm going to wish you the best of luck.
She ain't here right now.
I'm signing the document as we speak. What I want you to do is go to the window, get a copy of the paperwork, review it carefully, and call Mr. Haverko if you have any questions. Good luck to you, and thank you for appearing.
Yeah, just send them. Let me just see who else is here. Let's deal with Ms. Schubert's matter on the 10 o'clock. Why don't you come on up, Ms. Schubert? This is an old, if my reading of the docket is correct, it looks like it was previously an old failure to appear. So I believe this is actually a first appearance after a warrant. So we just asked to set another pretrial, and I'll get her contact information.
Good morning, ma'am. Is your full name Nicole Ashley Schubert? Have you been to court here on this matter before? You have been? I presume that a plea of not guilty has been entered?
Yeah, I believe so. Get phone number. Okay.
That case does go back to July of last year, but give you a notice of hearing, resetting the matter. I want you to exchange contact information with Mr. Haverko. Be in touch with him.
For some reason, it didn't take her signature. Let me try it again. Gave me some weird error message. I don't know why. Give it one more try. Sign again,
Something's
please.
happening.
Yeah. Okay, it worked that time. And I've got your contact information, so I'll be calling you about a week prior to the next birthday. Yeah. Yeah. And then before you go, I'll print up a copy of what happened today. So you'll have your court date in the paper.
The notice resets your matter to May 8th at 10 o'clock in the morning. Sure, I want you to go to the window outside the courtroom to your left, get a copy of the notice to remind yourself of when to be back here. And again, stay in touch with Mr. Haverko. Any questions? Take care of yourself.
On the 11 o'clock, let's call Melissa Olson.
Morning, ma'am. Is your full name Melissa E. Olson? Good morning.
We placed a motion for continuance and a speedy trial waiver into O courts and would ask the court to reset.
How far would you like to go?
Ordinary course is fine.
May 8th work?
Yeah. You'll get paperwork for it too.
Ms. Olson, yes, stay in touch with Mr. Haverko. Law-abiding behavior, that includes abiding by any protection orders that are in force and effect. Any question at all? Resetting the matter to May 8th at 11 o'clock in the morning. What I want you to do is go to the counter outside the courtroom to your left, get a copy of the order of reset, and we'll see you back here in May. Thank you, ma'am. Take care.
Mr. Pruitt? On the 11 o'clock? And I would just inquire to the court, hopefully it's in the court file. There should be in the court file in Mr. Pruitt, there should be a deferred prosecution evaluation. They just, for some reason, it didn't get to me, but they sent a copy to the court, I think. So I'm gonna, we're petitioning for deferred prosecution. I'm gonna have him sign these documents now, if full courts would work. Not to get him waiting.
Oh, courts, Mr. Pruitt, for the record, your name is Jeffrey Brandon Pruitt. The computer, the system for Old Courts is the name of it, is
At some
not
point,
responding very well today.
at some point, do I need to close the browser and just open up a new browser?
I've had good luck hitting the refresh button, but
It's spooling.
yeah, mine's, I'd like to say spinning wildly, but it's just kind of struggling. Mr. Pruitt, I'm pretty familiar with what's involved with this anyway. It's my opinion that a deferred prosecution is the harder way to go a lot of the times. Yeah. Oh, all right. I'm now having the
And then we gotta sign the order.
the petition. The petition does put a lot of weight on your shoulder. More hoops to jump through than are comfortable. You've got a lot to do. That's a lot of work. Yes, I am looking at the more important thing, the Northwest Resources eval. The recommendation and the evaluation do fully qualify you for a deferred prosecution program. And again, you're putting a lot on the line here. You're obligating yourself to do a heck of a lot of work. But let me tell you this, it's worth it. From what I've seen over the years, it's very much worth it. You're in a position where, you know, and I've seen a lot of people, clients, et cetera, family members, you can go this way or you can go that way. Some of them, the people I've represented, et cetera, they've done very well. And it looks like, from what I'm seeing right now, it looks like somebody that's committed to doing well. I know a few others that aren't among us anymore because their way of life eventually killed them. That's got a lot of good things. It's you know, I hear that a lot. You know, once you get involved in it and your body chemistry starts to reorient itself. your perception, outlook, et cetera, sleep habits, where everything is, kind of takes a turn for the better. That will come. That will come. That's, yes, that's, I read something about that, some time ago that, yes, the process of a nightcap or sleeping it off. However, when the alcohol wears off, you're met with the adrenaline rush that, sort of counteracts and destroys the whole effect. So keep working on it. Don't be patient with it. Be patient with yourself. There's the old line about, you know, the doctor, how long is it going to take for you to heal me? Doctor says, how long did it take for you to get sick? It was, you know, it's just be patient. And I'm still struggling here with E-courts. Believe me, I will sign the order approving of the deferred prosecution, and I'm going to wish you the best of luck with it. And as they say, it is a one day at a time process. So I just saw where it's supposed to be your last court date, but and so, some judges like to have people at the end come in later, but 5 years, I don't know if I'm still going to be alive that far down the road. Yeah, as long as as long as we're getting the compliance reports from the treatment center, that's you don't have to put up with listening to me or anybody else in the courtroom. I'm sure you've got better things to do than hear me pontificate about this, that, and the other thing. I'll end it by saying I am signing the order approving you into a deferred prosecution, formal 1005 deferred prosecution program. And I wish you the best of luck, all the luck in the world. Stay with it. Stay with it. Screw it. What I want you to do, get a copy of the paper that we're referred to today at the window. Go over it carefully, and again, I wish you all the luck in the world. You take care of yourself.
Oh, no problem. No big deal. No big deal.
Be well.
Oh, okay. Next matter on the 10 o'clock would be Megan Norgard. So we placed, well, matter comes on before the court for a pretrial hearing on charge of theft and criminal trespass. Parties have reached an agreement. She's going to enter a straight plea to count 2 criminal trespass. Upon the court's acceptance of the plea, city will move to dismiss the theft charge. City's going to recommend all suspended jail time, 364 days in jail, all suspended for 12 months on the condition of no new criminal law violations. And let me just double check something here. Actually, she's not arguing costs, so the cities are asking for a $250 court fee, and we agree to that.
And you agree to that?
We agree. We agree.
Good afternoon. Ma'am, your full name, Megan Kelly Norgard. Good afternoon. I'm looking at a statement of defendant on plea of guilty to 1 count of criminal trespass, 1st degree, accompanied by a motion to dismiss a theft 3rd degree charge, which was issued at the same time. Plea form tells me you're 26 years of age. You've been through the 8th grade. Any trouble at all following Mr. Averco in explaining the plea process to you? Any questions you might have had? Were they answered? And I'll be asking you if you have any questions of me at a point here. I accept the plea. You give up the rights contained in paragraph 5. No trial, no appeal. There will be a sentencing if I accept the plea, which will be up to 364 days in jail and up to a $5,000 fine, which I'd be free to impose regardless of what's recommended by the city and by your attorney. You realize that. With that in mind, as to 1 count of criminal trespass, 1st degree, alleged to have occurred within the city of Yelm on February 8th, 2025. How do you plead, guilty or not guilty? Do you make that plea of your own free will? Anybody make any threats or promises to you to make you plead guilty? Any questions of me about the process? I will find your plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. I have to find that, I can't have people pleading guilty to something they didn't do. I've heard the recommendation. Mr. Haverko, anything to add?
Nothing to add from me.
Mr. Hatfield, anything to add? Ben, anything you'd like to tell me? You don't have to say anything, but if you have anything I should know, now's the time. Okay. Stargard, I'm gonna follow the recommendation. All jail time, 364 days suspended, on the conditions that you pay a $250 monitoring fee, and far more importantly, stay out of trouble. No law violations. You're not getting in trouble for paying a fine, but you will get in trouble for violating that order, that you have no criminal law offenses. I'm going to wish you the best of luck. You take care of yourself. Get a copy of today's paperwork at the window and read it over carefully. And if you have any questions, give Mr. Haverko a call, okay? Thank you, ma'am. You take care of yourself.
There you go. Yeah, just, if you want copies of the paperwork, just turn left and go see the clerk and the paperwork from today. Yeah. No, not what you want. You can do it. Yeah, you can just go.
Good luck, Ms. Stargard.
Let's see.
Well, she went that way instead of that.
Well, I think she indicated, she says, well, do I have to have it? And I said, well, only if you want it, I guess.
That's one of the conditions of the suspended
Victor, why don't you come on up?
Mr. Messias Perez, good morning.
Good morning. So Mr. Messias Perez has three matters on today, two of which are pretrial hearings. The pretrial hearings, each of which are count one, suspended driving third degree, count two, ignition interlock device violation. He's going to be entering pleas to two counts of ignition interlock device violation. The city will move to dismiss each count of suspended driving third degree upon the court's acceptance of those pleas. City's recommendation is all suspended jail time on each of the interlock device violations. Because there's two cases, and part of Mr. Messias Perez's difficulties are financial. The total cost is $250, which is $125 each. You know, he already has the financial burden as it is, so trying to cut that down a little bit.
Well, we'll address docket number 3 later. Good morning, sir. For the record, is your full name Victor Manuel Messias Perez? Is your full name Victor Manuel Messias Perez? I'm looking at a statement of defendant on plea of guilty to 2 counts of operating a vehicle without ignition interlock, one on February 9th, 2025, and the other on March 10th, 2025. Each of those is what they call a gross misdemeanor. The maximum penalty on conviction, 364 days in jail and or a $5,000 fine. The plea form also references a dismissal of 2 driving license suspended or revoked third degree charges. If I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing, could be up to the maximum if I saw fit, regardless of what's recommended. You agree? And of course, the rights in paragraph 5, they're gone. No trial, no appeal, just a sentencing. With that in mind, as to one count of operating a motor vehicle without ignition interlock within the city of Yelm on February 9th, 2025, how do you plead, guilty or not guilty? And on March 10th, same offense, operating a vehicle without ignition interlock, guilty or not guilty? I'll find the pleas to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of each offense.
Oh, he wanted to have support about, you know, the need for an interlock if he's not driving. We talked about that and I said, yeah, if you're not driving and, even if it's your car, as far as I understand, even if it's his car, as long as someone else is driving, not him, I don't believe you have to have an interlock on the car unless he's driving.
Signed to that effect, that's with the caveat that to reinstate your license, the Department of Licensing is going to require.
Right.
That's
Right, we talked about it.
installation of, even if you have a dead car in the parking lot,
Right.
they're going to require installation, I think for 4 months or
Right,
something.
right.
But yes, that is true. But if you keep getting pulled over and you're the guy behind the wheel and you're the guy that has the obligation, you're going to wind up with the citation.
Okay, Your Honor. You see, I am a.
But I think he's asking the same question again, and what I told him was, if, whether it's a friend, relative, employee, whoever, if they're driving you around and they're the ones driving, then you don't
It's okay.
have to have an interlock device.
You don't need interlock to be a passenger. You don't need ignition interlock to be a passenger in a car. Just the driver, just the driver. That was that. And unfortunately I'm not aware of any work permit that can be obtained in this circumstance, or not, there perhaps should be, but that's not the case.
What's that? It was. No, what he just said was, you don't need an interlock if you're not driving. But if you ever want to get your license back someday, one of the preconditions is to get an interlock.
You'll have for a period of time.
Yeah, and you have to talk to the DOL about the specific period of time for reinstatement.
Okay, I do have a friend who's willing to finance me internet. So I must well go ahead and get it.
So, well, yeah, if you have a friend that's willing to pay for the interlock, sure, yeah, great, yeah.
If you have a chauffeur, if you have somebody that's willing to do that for you, that's the way to go.
Yeah.
Unfortunately, that it's the Department of Licensing that has the requirement here. I don't have anything to say about that at all. All I can do is impose jail time if you're convicted of it. And this goes back to the January of 24 underlying offense, and that's what we need to talk about as well.
Right. Well, I've discussed with Mr. Macias Perez with regard to the DUI case. As far as I understand it, no proof has yet been provided. I looked through the docket.
Nope.
There was no proof of victim impact panel, ADIS, or treatment. And so I spoke with Mr. Macias Perez, and he indicated he's aware of these requirements. The difficulty he's just had is financial. You know, he's just had a difficult time, you know.
Money.
Yeah, it's money. And so he, you know, to the extent the court's willing, you know, ask for more time if there's still some, suspended time
Yeah,
left, suspension period left. He'd ask for more time if that's possible.
City has no objection. The important thing is the drinking and driving. That's by far the most important thing here. These are things you have to do at some point. Always better late than never, but you're not gonna ever get in a lot of trouble with me as long as you're behaving, no criminal law violations, and doing your best. But yes, these are things that you have to do at some point. And yes, it does take money. But anyway, follow the recommendation. 364 suspended on each, 125 on each for a total of 250. And here we are. The hole keeps getting deeper the more, unless you quit digging. So quit digging. Quit driving.
Oh, yeah, driving is.
I've signed what I need to sign here. Get a copy of the paperwork at the window outside and to the left. And good luck. Take care. That's hope not to see you back. That's up to you. Take care. You got to get yourself out. I agree. Take care.
Next matter, I think, will be Mr. Delargy. You should come on up. Have you started treatment?
No,
Yeah. Oh, first thing. Turn this into the courtyard. This is it. So this is the 30. Okay. So this is Mr. Delargy, and so what we had originally is an evaluation that was submitted through Freedom Recovery, which indicated an alcohol issue justifying a course of treatment. Mr. Delargy then went to another treatment place called First Things First, and they indicated that he had no significant problem. And then there were questions about whether or not they had all the
Yes,
relevant, information. He has been trying to get, reassessed in light of a Freedom Recovery's evaluation. He was trying to get reassessed with First Things First, but he's been unsuccessful in getting an appointment there. So I guess still in the pursuit of a second evaluation, I've been handed a proof that he paid, a couple days ago, looks like $85 for a chemical dependency assessment at a third provider, which is Providence Behavioral Health and Recovery. So I guess my understanding would be is that he still wants to have what he believes is an objective second opinion, because I guess inherently
Yes.
what he's saying is he doesn't agree with Freedom Recovery, is what I would gather.
The concern, of course, is we always have is shopping for the best
Right.
what you want.
Right,
And it was my concern that the second evaluation had no idea that the
Right,
first,
right,
and Mr.
right.
Delargy didn't seem to understand that.
right.
We have received a request from the third treatment agency, and we'll comply with the request to send them the information, including any prior evaluations. They're entitled to
So I,
have that as part of the process.
right. And so when do you think you'll have that evaluation process completed through Providence? So I'm wondering unless if court wants to follow up, I guess my
Oh, yes.
suggestion would be to, reset it with an adequate enough time to receive the evaluation,
And what
from-
agency is it
from-
with? I
from
forget.
Providence.
Providence?
Yeah.
They're fairly quickly. They're fairly quick. I would suggest probably May 8th.
Yeah, I would think
Would
that
that-
should be enough.
That should be, we're going to reset the matter for May 8th. I want to readdress it then. So, Mr. Delargy, we'll give you a notice of hearing for that date. The O court system is
Oh,
leaving a lot to be desired today, I should say, but as soon as we can prepare that,
yeah.
you'll be able to get a copy of that at the window. Yeah, May 8th. We'll see you back here then.
Does he need to sign the order on review?
No,
Oh, okay.
we'll just give him a notice.
Oh, okay.
Docket will reflect he was
Gotcha.
here.
Okay.
Mr. Delargy, I might say, I have long held the belief that whoever does the evaluation should not be the agency to do the treatment. I just see too much of a temptation in some of these evaluating agencies. Well, you don't need our $100 tune-up. You need our $1,000 lessons. It's if you're there's too much self-interest involved in it to me, but that's just the way I feel. I don't have anything to say about that. So good luck to you. Get a copy of today's notice at the window outside and to your left, and we'll see you back here in May. Take care.
That's okay. No big deal. No big deal.
Oh, shoot, I could have, yeah. Signing. Didn't see.
Next matter is going to be Rachel Blake. It's item number 1 on the 11 o'clock calendar. Matter
Yes.
comes before the court for a pretrial hearing on a theft charge, and the parties have reached an agreement, that being a 12-month stipulated order of continuance, conditions of which are no new criminal law violations, a $250 court fee, at the end of which time then the city would move to dismiss.
Morning, ma'am. For the record, is your name Rachel, middle initial S, Blake? Do you disagree at all with anything Mr. Haverco just said about the disposition of the case? What we're gonna do here? Okay. I gotta make sure that is the case. It's a contract between yourself and the city. I'm not a party to the contract. Mr. Haverco negotiated it for you. If you stay out of trouble, pay any costs, most importantly, stay out of trouble. The charge will be dismissed. Now, in return for this agreement, you've given up your right to go to trial, cross-examine witnesses, appeal if you lose at trial. If you violate this agreement and the city proves that, we'll have a hearing based on the police reports and that would almost certainly result in a conviction for a gross misdemeanor, theft in the third degree, with a maximum of 1 day less than a year in jail and a big fine, 5,000. I'm hoping that this is a learning experience, that you've learned from the situation, and there won't be any reoffending. You can pay the probation monitoring fee at the rate of $25 a month. First payment due April 27th. Any questions at all? All I can do is wish you the best of luck. I'm hoping that you have learned from the experience. In any event, I won't be able to tell. Time will tell. Good luck to you, and be well. Be the best person you can be to yourself. What I want you to do is, it's kind of a lengthy agreement with a lot in it. What I want you to do is go to the window outside the courtroom to your left, get a copy of it, and read it over carefully, and give Mr. Haverco a call if you have any questions. You take care. I will. Oh, and you as well. Thank you. And
Did
not
we-
seeing anybody else, I guess
did-
that
did
takes
we-
us to the no-show.
Did we want to call it's just a housekeeping matter, Diane Thomas, that was number 8 on the 11 o'clock. We had received evidence that she's deceased. So we just need to just dismiss it, so it's closed.
She is now gone to a higher jurisdiction than ours. It's yes, the charge will be dismissed. Born in 63, not that old of an
No.
individual.
Not at all. The only remaining person on the 10 o'clock is Marcus Williams. I did have recent contact with him, and I thought maybe he'd be showing up today wanting to reset maybe a bench trial. And so he didn't give me he didn't notify me or send me any messages that he wouldn't be appearing. And so I don't have any information as to why he's not here, but I can just represent that I've had contact with him within the last week.
Given the nature of the charge and your contact, I'm inclined to note the non-appearance for speedy trial purposes and reset with notice.
On the, might be a little too early, but on the 11 o'clock, I have on Joseph Carley. I have called a few times. I have a number, but and I've called more than once, left a message, and have not received any return call or contact on Joseph Carley. But it's only 11:16, so who knows?
The non-appearance, 1,000 cash or bond, however, we'll address the matter if he shows up before the end of the day. What now?
That's it. Done.
Oh, hey. Go ahead, Donnie, bring up Mr. Curtis. Morning, Mr. Curtis. We'll address your matter now. You're here on behalf of Destiny Wilson, I believe.
Yes, Your Honor, and James Curtis appearing on behalf of Ms. Wilson. Your Honor, we're moving the court to allow defendant to appear through counsel under 3.4, and we're asking the court to set this matter over. This is my first pretrial conference, and we're in the process of completing some evaluation, and we need additional time to get that done so we can negotiate the case for a resolution.
And trying to reset it out. How about May 8th? Would that work?
Yes, and I have an order and I'm submitting it right now, and I just finished it right now. It's in Oak Courts.
I'd like to change that to 9 a.m. If that would work a lot better for us if I could have that at 9.
That's fine, Your Honor. Thank you.
We'll do that. Approve of the, I'll sign the, when that's amended, I'm going to sign the order of reset. We'll be sending both yourself and Ms. Wilson a copy of today's order.
Okay, Your Honor, do you want me to go in there and change that really quick?
It's already changed.
Oh, it's already changed. Okay, thank you.
Not by me. I'm a computer dinosaur, but
Well, I'm sure you got some very helpful people around you who can do that for you.
be totally lost without my my clerk here, who's something of a whiz.
Sounds good. Thank you.
No. Mr. Curtis, you take care. Have a good day, and we'll see you again on the 9th or the 8th of May.
Thank you, Your Honor. Take care. Have a great weekend.
Good afternoon. We'll go to the 1 o'clock arraignment calendar. I will call you up one at the time, but before I do that, I need to advise you of a thing or two. You have a right to have a lawyer represent you at all stages of any criminal proceeding. If you're indigent, a lawyer will be appointed to represent you throughout the course of your matter. Mr. Haverco, our public defender, is at the council table. In any event, he will enter a plea on your behalf at this time. The plea at this stage of the proceedings is invariably not guilty. Not any great statement about the case. It's simply a way of preserving your rights pending what they call a pretrial. You have to have a chance to negotiate a resolution of your case with the city's representative, Mr. Atfield, who's seated here to my right. If that cannot be done, if you cannot agree to a resolution of the case, you do have a right to a public and speedy jury trial in the county where the offense was alleged to have been committed. If you have any questions about what you're charged with, what your rights are, I'll ask you to ask me or Mr. Haverco. I think there are some private counsel matters here. I prefer to call them first. The public defender is going to be here all afternoon, but any private counsel matters, I prefer to call first. Do we have any private counsel? And your client is? It's pronounced Gracious? Okay. Good afternoon, sir. Is your full name Kurt Evan Gracious? If I mispronounce anybody's name, I apologize. If there's a way to mispronounce a name, I'm certainly going to find it. In any event, Mr. Gracious, you were cited on March 14th, 2025 with the offense of driving while under the influence of intoxicants. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll turn at this time to your attorney for the entry of a plea on your behalf. Plea of not guilty, as I indicated, does preserve your rights. We're going to set it for a pre-trial in April. The court dates are the 10th or the 24th, and private counsel matters are always heard at 9 o'clock. And if we need to go into May 8th or 22nd. That we will do. Mr. Gracious, the conditions of release are law-abiding behavior, no criminal traffic violations. Don't drive unless you're licensed and insured. Don't drink and drive at all. If any officer asks you to take a breathalyzer, you're to do so. There aren't any priors. I'm not inclined to any objection to the conditions, and those will be the conditions released. And in addition, stay in touch with your attorney and appear back for court as directed. And that will be April 24th, 9 a.m. In this course, I allow private counsel to appear by way of Zoom, but I do want the defendant to be here in person. I'm signing in O Courts a order on arraignment. I'll say this for the benefit of everybody. Go to the window outside the courtroom to your left and get a copy of today's order. And then we'll see you back here on the 24th of May. Any questions at all? Thank you. I think you may have somebody else. Mr. Benton, if you would step forward, have a seat, please. Full name Nathaniel Benton, Jr. Mr. Benton, the citation I have alleges that on or about February 4th, 2025, you committed the offense of assault in the 4th degree DV. That charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. At this point, I'll turn to your counsel for the entry of a plea on your behalf. Benton, that does preserve your rights pending a pretrial. Probably set it for the same.
Yeah.
24th, 9 a.m. Yes. As far as I'm concerned, he may do that. And as far as no contact is concerned, I'm inclined to impose, I'll defer to counsel a little bit on that. No hostile contact as a condition of release instead of entering any sort of no formal order given his military status. Yes. And the world we live in now, I'm not sure what is going on. I agree. Yeah, no hostile contact. That's not really capable of any precise definition. What it basically means is if there's a problem and the police have to come, guess who's probably going to get arrested? Well, that's, I don't know of any better way of explaining it than that. We're setting a pretrial for the 24th of next month. And again, stay in touch with your lawyer and appear back here for court as direct. I am signing electronically as soon as O Courts lets me do that. They've been signed the order of reset. And again, you can get a copy of the today's order at the window outside the courtroom to your left, and we'll see you back here next month. Thank you. And I don't think we have an NOA on. It'll be forthcoming. Hey, thank you. Take care. Is Michelle Almendinger here? Michelle, yes, I remember you. You telling me that. And full name, Michelle Ann Almendinger. Ms. Almendinger, the citation alleges in honor about March 20, 2025, you committed the offense of disorderly conduct. That's a simple misdemeanor. The maximum penalty on conviction would be 90 days in jail and or a $1,000 fine. I'm going to appoint Mr. Haverco to enter a plea on your behalf. He'll represent you throughout the course of the matter.
Stipulate the probable cause, Your Honor. Ask the court to enter not guilty plea.
Ms. Almendinger, a plea of not guilty does satisfy your rights and preserves them pending further proceedings.
Can you figure out what it is? Okay. Oh, yeah.
Ms. Almendinger, yes, I want you to give Mr. Haverco your contact information. The order setting a pretrial for May 8th at 10 o'clock, that's going to have Mr. Haverco's contact information on it. Do you have any questions? Hey. Almendinger, thank you for appearing. You take care. Jordan Bargain Carter does not answer. A number of people won't answer. They will not appear. After I've spoken to everybody, I'll go back through the case. And if there was probable cause to issue the citation for the individual who did not appear, that's a warrant will be issued for their arrest. So I want to thank you for appearing. You saved yourself at least the issuance of a warrant. Jordan Bargain Carter does not answer. How about Christine Barrett? Good afternoon, ma'am. Full name Christine Lynn Barrett. Ms. Barrett, the citation alleges that on or about March 16th, 2025, you committed the offense of theft in the third degree. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to enter a plea on your behalf, and he'll represent you throughout the course of the matter, should you be indigent.
Stipulated probable cause, Your Honor, ask the court to enter not guilty plea.
Ms. Barrett, a plea of not guilty does satisfy. Satisfy the requirement that you be advised. Do you have any questions at all? You've signed an order resetting the matter for a pretrial on May 8th. What I want you to do is get a copy of that order outside the courtroom and to your left. Conditions of release, of course, are law-abiding behavior. Stay in touch with Mr. Haverco and be back here on the 8th of May, okay? Any questions? Thank you for appearing and good luck.
Just go get a copy of your paperwork and I'll call you about a week before your court date.
Ronald Besaw, B-E-S-A-W. Does not appear to be here. How about James Bittner? Does not answer. Xavier Canel, C-A-N-E-L. Good afternoon, sir. Full name Xavier Ryder Canel. The citation I have alleges that on or about March 24th, 2025, you committed the offense of driving while under the influence of intoxicants. That charge is a gross misdemeanor. The maximum penalty on conviction, 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to represent you at this hearing and throughout the course of the case, should you be indigent, and ask for his services. Mr. Haverco?
Stipulated probable cause, Your Honor, ask the court to enter not guilty plea.
Mr. Canel, a plea of not guilty has been entered on your behalf. That does preserve your rights. We're setting a pretrial for May 8th, 2025. Now, I want you to give Mr. Haverco your contact information. There is an infraction that was issued along with that. We'll calendar that along with the criminal offense. Canel, I thank you for appearing. Don't forget to get a copy of the order at the window outside the courtroom to enter your left. Hey, thank you, sir. Take care. Reginald Coleman. Reginald Coleman. Good afternoon, sir. Go ahead and have a seat. Full name Reginald, middle initial M. Coleman. Yes. Mr. Coleman, the citation alleges that on or about March 11th, 2025, you committed the offense of theft in the third degree. Again, that's a gross misdemeanor. The maximum penalty on conviction, 364 days in jail and or a $5,000 fine. Appoint Mr. Haverco to enter a plea on your behalf, and he'll represent you should you be indigent to request his services.
Stipulated probable cause, Your Honor, ask the court to enter not guilty plea.
Mr. Coleman, plea of not guilty does preserve your rights. We'll set a pretrial for May 8th at 11 o'clock. That'll be on the order that we'll sign today. Any questions at all?
You have a phone number?
Woman. Thank you for appearing. Any questions at all?
Okay.
You take care. We'll see you back here, May 8th. You take care. Don't forget to get a copy of today's order at the window, outside the courtroom and to your left. Good luck to you.
Okay.
Tyron Edwards. Does not appear. How about Jennifer Flowers? Well, next would be Tracy Guerin, Guerin. Good afternoon, ma'am. Full name Tracy, middle initial J. Guerin, did I pronounce that right? I was lucky. Citation alleges in honor about March 19th, 2025. You committed the offense of assault in the 4th degree DV. Gross misdemeanor, the maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Havercode to enter a plea on your behalf. He's going to do that at this time.
Stipulate to probable cause, Your Honor, ask the clerk to enter a not guilty plea. Yep.
No hostile.
400. Are they both civil?
Karen, the condition of release would be law-abiding behavior and no hostile contact with Nikki Guerin. Is that? Pardon? Okay. Stay in touch with Mr. Havercove. Law-abiding behavior, stay out of trouble. And I don't want any trouble. So no hostile contact with the alleged victim in this matter, Nikki Guerin. Is she by any chance in the courtroom? Is there going to be any ongoing problem? And your safety concern is, okay, that's good then. Whatever it takes to keep the peace. That was, Ms. Guerin, thank you for appearing. Again, get a copy of today's order and at the window outside the courtroom to the left. Good luck to the both of you. Thank you, man. Jeannie McDaniel. Anthony Nelson. Good afternoon, sir. Full name Anthony, middle initial J. Nelson. Citation alleges in honor about March 19th, 2029. You committed the offenses of criminal trespass, 1st degree. That's a gross misdemeanor. The maximum penalty on conviction, 364 days in jail and or a $5,000 fine. You're also cited for a use of drug paraphernalia. That's a misdemeanor. Maximum penalty on conviction for that would be 90 days in jail or a $1,000 fine. I'll appoint Mr. Havercode to enter a plea on your behalf. He'll represent you throughout the course of the matter if you're indigent.
Stipulate probable cause, Your Honor, ask the clerk to enter not guilty, please. Have a phone number or anything? Okay. Oh, okay. Oh, okay, current circumstance.
But he's your lawyer right there. Right. That's no, if you can't, you can't. We will give you a copy of the paperwork for today. You get that at the counter outside the window. Pre-trial set for May 8th at 11 o'clock. And that'll be on the order, as well as contact information where Mr. Haverco, he'll represent you and enter a plea on your behalf.
Yeah, right. Plea not guilty on both counts.
Mr. Nelson, any questions at all? I want to thank you for appearing. We'll see you back here on May 8th, okay? Well, I hope he has a good memory. He just left. Jeremy Olson does not appear. How about Alexander Petruson? Peterson, I apologize. Like I said a bit ago, there's a way to mispronounce a name. I'll do just that. Citation alleges in honor about March 21, 2025, committed the offense of driving under the influence of intoxicants. That charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to enter a plea on your behalf. He'll do so at this time.
Stipulated probable cause, support to enter not guilty plea.
Just you can get a copy of the order at the window outside the courtroom to your left. Any questions at all? Law abiding behavior, don't drive unless licensed and insured, don't drink and drive at all. And any officer asks you to take a breathalyzer, you're to do so. And we'll see you back here on the 8th of May. And Mr. Haverco's contact information, that'll be on the order you can get at the counter. Good luck to you. Take care. Christina Russell. Huh. How about Rodana Schaefer? Good afternoon, ma'am. Full name Rodana Lynn Schaefer. Citation alleges in honor about March 15th, 2025, you committed the offense of theft, the 3rd degree. That charge is a gross misdemeanor. The maximum penalty upon conviction for that would be 364 days in jail and or a $5,000 fine. Ms. Schaefer, I'll appoint Mr. Haverco to represent you. He'll enter a plea on your behalf at this time.
Stipulated probable cause, support to enter not guilty plea.
And that, of course, preserves your rights. We'll set it for pretrial. I want you to give Mr. Haverco your contact information.
The number to reach is this good? Is that yourself? Okay, good.
Schaefer, thank you for appearing. You take care. We'll see you back here in your pretrial and have a good day. Sherry Tolosa? Sherry Tolosa. Does not answer. Lawrence Webb. Good afternoon, sir. Your name is, full name Lawrence Lane Webb. Mr. Webb, I have reviewed the police reports. I always do that in certain cases. And I'm not finding that the officer had probable cause to cite you for the offense he did, driving under the influence of intoxicants. Therefore, unless the city has any objection and wants to make any argument, I'm going to dismiss the citation. I don't either, but I'll speak up. So how does that work? I'm not finding that the officer had a sufficient legal reason, shall I say, for citing you for driving while under the influence. That being the case, I'm going to dismiss the ticket. Yeah, I'm assuming you have no objection. Okay, any questions? That concludes the hearing. You take care. Mr. Webb, you as well. And you've been waiting here, pardon? Now, as is the case with the last individual, if you're here for a hearing, come on up and have a seat at the council table. And if you would, go ahead, have a seat.
What's your last name?
The last name is 1 o'clock. Jordan Bargain Carter.
Oh.
Is that your full name? Jordan Bargain Carter? Citation alleges in honor about March 12th, 2025, you committed the offense of theft in the 3rd degree. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to represent you in this matter. He'll enter a plea on your behalf.
Stipulate to probable cause, Your Honor, as the court tenor or not guilty plea.
I want you to give, excuse me, I want you to give your attorney your contact information, a phone and number and an address.
Okay. Okay. No. Okay, let's see. That's working. Yeah, and if you have a new address, it's supposed to have some clerk to do it.
That being the case, sir, I believe you're Mr. Basaw, I think, I'm gonna guess.
Gotcha.
Mr. Haverco, this is the
Right.
same incident. It does not appear that there's a conflict of interest, but should a conflict arise, Mr. Basaw, that's we'll
Right.
deal with that
Right.
at the time. Full name, Ronald Leroy Basaw. Citation alleges in honor about March 12th, 2025, you committed the offense of theft in the 3rd degree. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. You're also cited for driving license suspended, revoked 3rd degree. That's a misdemeanor. 90 days in jail and or a $1,000 fine would be the maximum upon conviction for that.
Would stipulate to probable cause on both cases and ask the court tenor or not guilty, please.
Plea of not guilty,
Phone number?
having.
Oh,
us off. You've signed, given Mr. Haverko your contact information. That concludes the matter. I'll want you to get a copy of today's order at the window outside the courtroom to the left. Conditions release, stay out of trouble, law-abiding behavior, stay in touch with Mr. Haverko, and show back up here on May 8th for your pretrial. Any questions? Take care. On record for the no-shows from the 1 o'clock arraignment calendar. First one I have is docket number 7. Citation for DWLS, amend that to no vol, second degree, and FTA it. The next one I have is, next page, docket number 11. Tyrod Edwards was cited with failure to transfer title within 45 days. Amend that to expired tabs, FTA. Jennifer Flowers likewise did not appear. Amend expired tabs or expired title to tabs and DWS third 2, no vol 2, and FTA. Next page, docket number 15, Jeanine McDaniel cited for DOS third. Amend that to no vol 2 and FTA it. Next would be number 17, Jeremy Olson, DOS third, amend to no vol 2 and FTA it. Then Christine Russell. I find probable cause for the issuance to her for all items, 9:45 and 10 o'clock. PC found when I spoke to her in custody. Warrant will issue 1,000 cash or bond each charge for a total of 3 warrants. Last would be Sherry Lee Tolarosa. She was dealt with in custody as well. Booked in for a protection order violation on March 5th, got released, went right back out and violated it again on March 12th. Probable cause 1,000 cash or bond each charge, docket numbers 22 and 23. And I think that is it unless I missed something. With that, we can go off record. Good afternoon. We'll go to the 2:30 mitigation contested calendar. Is Christopher Pena here? So, Mr. Pena, go ahead and have a seat if you would. You've asked for a mitigation hearing. They're both non-moving violations, no insurance, and failure to renew a registration. I can understand why you want to mitigate insurance. That's $559 on its face. Failure to renew registration is $237 for a total of $796, which is way too much. Mr. Pena, did you have insurance at the time? Have you gotten it since? What's the?
I did have insurance. I just couldn't find my card.
Do you have it now? With
Yes,
you?
sir.
Can I see it?
Yeah, bro.
Come on up, sure. Jacksonville fan. Very good. Hey, great. What I'll do is this. We'll dismiss the insurance tickets upon payment of $25 in costs. That's better than $559. And failure to renew expired registration, you've taken care of that. Let's reduce that to 100. Total of 125. You can pay that at 25 a month if that works. And that does first payment due April 27th. Now I'm signing an order to that effect. Oh, absolutely. Sign an order to that effect. You can get a copy of the order at the window out in front. What I want you to do is, make the payments. The minimum is what is set forth in the order. If there's a problem making the payments, let us know. That we can certainly deal with.
Okay.
Any questions at all?
No, sir.
We'll see if they have a good season next year.
Yeah, I hope so.
Good luck.
Thank you, sir.
Hey, thank you. Chantel Cier. Good afternoon, ma'am. You're cited for, the no insurance ticket, $559, and speeding, with a penalty of $370. Boy, that's a little pricey. So yeah, what I was checking to see there is whether you're eligible for a deferral or not, in this case. And then with regard to the speeding ticket, you might want to do that. Now, as you might know, you're only allowed to do that once every 7 years for a moving and 7 years for a non-moving. So if you want to defer both of them, we'll reduce the payments. Yeah, it's $929 as we on the face of the ticket. For a deferral, we would reduce that to 100 each. And with the requirement that you not have any more citations over the next 4 months. If that turns out to be the case, both tickets will be dismissed.
I had insurance at the
Oh,
time.
you did have insurance?
He told me he didn't have the time to wait.
Do you have proof of that now, or?
Yeah,
I'll
it's
take
in
your
my
word for it.
car, but
I'm gonna take your word for it.
okay. Yeah, I mean, I offered it to him. He said, I don't have the time to wait for it. He walked back to my window and said, oh, you do have it. Well, go fight it in court.
Well, I'm gonna send you ahead. I'm allowed to, based on the fact that you did have it, assess $25 and dismiss, which I'll do. The cost of a deferral on the speeding ticket, that's the important one, because face it, we're talking about insurance rates. Let's defer that for a period of 4 months. $100 paid, both of them off within the 4 months. The ticket will be both of them will be, no insurance is dismissed right now.
Okay.
Speeding ticket will be dismissed then. That's, yeah, I don't know what he clocked you at. I'm not,
Well,
But it must have been-
also, I think he clocked the guy in front of me and I asked, what about him? And he said, well, I got you. That guy in front of me was flying. So I feel like he clocked him and then ticketed me, but I'm not gonna argue, so.
that's, you know, I hear that a lot, and I've experienced that a lot.
Okay.
A lot of cars are driving.
Yeah.
And they'll say, no, clearly within the radar beam. But
Yeah.
who knows? That's yeah, anyway, it's being deferred. Pay the $100 within the next 4 months. The speeding ticket will be dismissed. Now I'm getting to, I'll do an order to that effect, which will take a minute. Yeah, and keep in mind, yeah, driving a car is probably the most dangerous thing you're ever gonna do in your life. Slow down.
Sure
There's a
will.
lot of people out there that are angry. I go to
Absolutely.
Bellevue, at least, every other week.
Yeah.
And
It's scary out here.
you know, it's getting to be that way.
Yeah.
Just the discourtesy, the anger.
Yep, better safe than sorry.
Yeah, oh, yeah, better get there. Being a lawyer, I've been involved in so many cases where they never got there. They wound up
Yep.
in the cemetery or
Yeah.
in the hospital instead. Good way to look at it. Monsieur, did I mispronounce your name?
It's C, that's okay.
See, okay. If there's a way to mispronounce a name, I'll do it.
Okay.
I'm signing an order to that effect as we speak. You can get a copy of that order by going to the window outside the courtroom and to your left. Any questions at all?
No,
Good luck, happy motoring, and
Thank
the
you.
better your record,
thank you.
the lower your insurance premiums. You have a good day. And thank you for your patience. Jandre Ivory. Good afternoon, sir.
How you doing?
So far, so good. It looks like you're here for a contested hearing.
Yeah. I was just over there charging my car at the park and, my house is over there, right by the bus barn, so I just had walked over there. Obviously I let it charge and walked back up there and, I was going basically, I was going through the light and the light went red. And then I'm all the way down, about to take a left towards the bed bar. My house is right there, like the bed barn the location of my house it's right there. So, he pulls before I make the left, he shoots down there and then I just roll into my property. So I stop right by my property. You know, I asked him why he pulled me over. And he was like, well, you flew through the red light. And I was like, oh, okay. And I was like, I flew through. And he was like, yeah. And then so if you read the statement that he made, he says that I was
You were what?
or were you pointing down to something?
You were arguing?
No, I said in the paper, in his,
The
what he-
statement?
in the statement, he was saying that
Got that right here.
yeah, that I was arguing, but I was asking what was the speed that you clocked me, but if I was going through if you seen me and you said I was going through, what was the speed? And he was like, well, you know, he wouldn't answer my question. And so then I was like, well, is the cameras, it's an intersection, did the cameras get me? And so at that point, I just didn't bother. He didn't give me a speed, nor did he said mumble something about the cameras, but at that point I was, and then I didn't have a driver's license, but I told him I'm just charging right there at the park. My wallet's right there, you know, I was just going to charge real quick. And so then he didn't budge on that, but I had insurance and everything else. So I was just kind of perplexed why he just added that on. So the whole thing about it is I just felt like, I didn't go through, I feel like he would, if I was smashing through the lane and he was seeing me, he would have clocked me. And then the fact that it was just, oh, I ran a red light, I don't believe that I did. I believe that maybe right when I got across,
it was, but you know, I'm gonna be honest, I don't think it was, and
Here's what we'll do. I didn't realize this for a long time, but, I've understood now that the rule is on, going through a lighted intersection, that if it's yellow, before you, as you enter the intersection, you're legal. If it turns red before you're out of it, you've entered it on the yellow, that's fine.
yes.
So, unless you've sped up to go through. So what I'm
No,
gonna
it
do
was
is-
just, yeah, like I said before, I live right across from the Bud Barn. Not the Bud, why did I say Bud Barn? I mean Bus Barn.
The
I
bus
don't know
barn.
if I said.
Oh, okay, yeah.
I might have
looked
said
that
Bud
way.
Barn earlier, but
You
I
did.
was right there charging, and then I went right down through that intersection, and then the next intersection right there, if you take a left, my house, my property starts at that end, and that's where I go in. So I was just charging in the middle of the night. You could see the time that it was. I just don't really want anything on my record. I work with adults with disabilities.
What we'll
and-
do is this, I'm gonna dismiss the, red light citation. That's the moving one. That's the one that would hurt your
Yeah,
record.
yeah.
You didn't have your license on your person. I'll find that you did commit that.
Okay,
It's a
yeah.
non-moving violation, shouldn't affect your insurance at all.
Okay,
And it's 145, and I'm gonna reduce that to 100.
okay.
You pay that at 25 a month, and yeah, but the difficulty I have with these things is I wasn't there to see it.
Yeah,
And these
yeah.
interactions, sometimes they get a little touchy, on the roadside.
Yeah.
I've had my share of them, but, myself, but.
Sometimes, not all the young police force, but just like the young lady was saying, I just wanna, jump on that. It's a little too much of okay, you go to court and handle it. And I thought that was a real, not sympathetic or any empathy, more of a mechanism, more mechanical like, and I just wanna let the court know moving forward, just with, not only with, blacks or whites or just anybody, really anybody in general, we shouldn't be having a lack of empathy and sympathy. If somebody
I
said-
agree.
and I just want to say moving forward, you already sounds like you're a man of just scales. So
I
I just
try.
want to say, just want to further tell you I appreciate it, just sitting in. And then also that, if you do see this being a issue moving forward, I think that you should speak to the force, because it's tough times all the way around right now. And
Sure is.
so you trying to do $900, $500, where are these people getting? They can.
Where's it gonna come from? If you can't afford insurance, how are you gonna afford 559 for a ticket for not having insurance?
Yeah, so that's all, and I accept what you, appreciate what you,
Well, it's, I'm glad to see it. I fully agree that, police officers, that's public safety is their main thing. And that you should try and have a good rapport and treat people as you want them to treat you
Yeah.
when you're out there in the street.
yeah.
Not, unfortunately, I'm not the morality police. I just do the best I can here. I've signed an order, to the effect of, the ruling I've made, Mr. Ivory, and, you can get a copy of that at the window.
Yes.
And again, if you have any issue, any problem making the fine payments, let us know. The money's not that important.
Yeah, I can do 25. When it's like you said, I didn't have the ID, and at the end of the day, can I ask you even though this is what I didn't understand also. If they're running my plates, doesn't my ID come up anyway when they run everything? So.
I know that they can get your driving record, and it'll say whether you're suspended or not.
But not,
But I think, yeah, the requirement is you have to have it on your person,
Okay.
and to show it to the officer.
okay.
It would, yeah, if I was the officer and I was writing the ticket, if I saw you were legally licensed, and there was nothing impairing your license, it wasn't suspended or at jeopardy, I'd let it go and said, hey, you gotta have it on you. And let it go at that.
Yeah.
But it wasn't me that was there.
Learn it. I'll keep it on me now.
All right. Take care and have a good one.
You have a great one.
Be well. One more matter, Christopher Kenny. Mr. Kenny, is that you? Come on up. I guess this is kind of a fine review. hearing. It looks like you've got it looks like we've got three, matters here.
Should be.
Some
four.
are in collections and some are not, and it looks like, $2, 3, 4, $602, in total for all three of them. What would you want me to do?
Right now, I'm homeless and my court appointed attorney knew that. And I've been looking for work and I haven't been able to find one because of my record. And I have no way to pay for it. I've even tried the temp services and they're slow also.
Have they suspended your license?
They did at one point, and I tried to explain this to the officer when I kept getting pulled over for no reason. My parents are paying for my insurance and stuff until I can find a job. Somebody took and somehow charged on their credit card and their bank was drained and they're waiting for the money to go back on it, and the insurance canceled it, and then they finally reinstated it, and the state took forever to do the SR-22. But I had the paperwork and stuff in the car.
Are you able to pay anything towards this?
Not at the moment, no.
5 cents, a nickel, a dime.
I've probably got
$5.
like 25 cents and that's it. I've been working with all these people saying that, oh, we could help you get a job with your record. And I've had job offers and I tell them everything and put it down in writing like on the application. And then they're like, oh, we can't give you the job, even though they offered me the job. I told them up front what's going on.
Mr. Kenny, I really don't know what I can do. We do have one matter that's in collections. We can pull that. If they haven't taken any action, then I presume they haven't. They usually just wait. We will pull that out of collections. 2 of these are traffic tickets. And as long as they aren't suspending your license, they're just there. We won't send them to collections, so you don't have to worry. But the $250 on the criminal matter, that goes back to what I would be inclined to do is let's just let that sit. And what I want to do is take another look at that. Yeah, any job prospects at the time?
I've been applying on Indeed left and right, going into like Burger King and all that, and they're like file online. So I go to the library and file online. I'm just waiting to hear back.
Let's set this for a review hearing. 6 years, no, 6. Oh. Let's take another look at this, say in, at the end of summer, how about August 28th?
Okay.
Let's set a review hearing for August 28th. We'll simply give you a notice of hearing, you can get at the window, and we'll just take another look at that. I'm not gonna take, find you in default and impose any jail or monetary sanction that, for this. The infractions one, let's just let that sit for now. It's not, no harm. That's but the criminal one, that has to be kind of taken care of.
Okay.
And we'll take a look at it and see where you are. Not gonna issue any warrant for your arrest or anything. We'll just take a look and see how you're doing by the
And
end
I'm
of the summer.
still fighting with Pierce County too, because they call him the clerk, I guess, in the window, told me it was modified. And that's the only reason why she was in the car. And my brake light was supposedly out and I got pulled over with her in the car.
That's, those things, they come back to haunt you. They come back to haunt you. Mr. Kenny, if you would go to the window, get a copy of the notice of the next hearing. August will be here before you know it, but you'll have it to put on your calendar and we'll just see where you are then.
All right, thank you.
In the meantime, we won't do anything.
All right.
We will pull the in collections so they won't be bothering you.
Okay, thank you.
Good luck to you and take care. Hope you find employment.
Hopefully.
Good to have something to do.